Okay. We'll go ahead and move on to argument in our second case set for today, which is United States versus Rivera, case number 24-673. And we'll hear first from Mr. Fish.
Good morning, Your Honors, and may it please the Court, Eric Fish, appearing for Mr. Rivera, the appellant. I'd like to reserve 5 minutes of my time for rebuttal. So I'd like to begin with the sentencing issues in this case, and in particular the drug approximation issue. This case is squarely controlled by United States versus Gonzalez-Sanchez, and the factual similarities are remarkable. In Gonzalez-Sanchez, the defendant flushed an amount of drugs down the toilet, and in Gonzalez-Sanchez, the judge used money found in the residence to determine the amount of drugs that were missing, to approximate the amount of drugs. And in that case, the finding was reversed, and this court instructed that in order to conclude that a certain amount of drugs were at the premises based on an amount of money, one needs a finding based on the record made by a preponderance of the evidence that the currency seized was the proceeds of a drug transaction. Without that, conversion into cash is improper.
So was there a jury, a special jury verdict in Gonzalez-Sanchez that found the amount of drugs?
There was no special jury verdict discussed in the opinion, Your Honor. There is a special jury verdict here. I can distinguish
well,
that.
And that's what I guess that's what I'm sort of leading into, right. Is that seems a pretty easy distinction in this case where you have a jury that actually found a specific amount. So why isn't that enough?
Well, so the jury verdict does not have estoppel consequences in this case for two principal reasons. First, the jury was instructed that they could find the money forfeitable either because it was the proceeds directly or indirectly of the drug dealing, or because it was being used it was intended to be used in the future for the drug dealing. That latter basis, which was available to the jury based on its instructions, would not support the drug approximation analysis. In addition, the jury's instructions said it could find it was either direct or indirect, the connection between the money and the drugs. If the connection is indirect, that is through some other item being sold or some other feature of Mr. Rivera's conduct that's connected to but not itself selling methamphetamine, that would also not support the drug approximation. So for both of those reasons, the jury verdict is distinguishable. The judge also did not rely in sentencing on this case on the jury's special forfeiture verdict. The only factor the judge discusses in imposing the sentence is the money that was found. And so we don't think that the forfeiture verdict supports the enhancements. In addition, the judge needed to sort of specify the amount of money, specify this particular source of the money, and go through an analysis of, on the record by a preponderance of the evidence of how that money supports the conclusion with indicia that the money was from drug transactions, that a certain amount of methamphetamine was present. Cases cited in Gonzalez-Sanchez that satisfy this condition have much higher sort of thresholds of evidence than was present here. So, for example, in Stevenson, members of the defendant's drug distribution ring habitually arranged their proceeds in a particular and readily identifiable manner. We don't have that here. We don't have evidence of how, money from drug transactions were arranged. Also, in United States v. Hicks, the defendant admitted that the majority of the money came from drug sales. Obviously, we don't have any sort of admission here. So for that reason, I believe the drug approximation enhancement should be reversed. I can move now to the premises enhancement. So the purpose of the premises or stash house enhancement is not to impose higher sentences on people who sell drugs and also live in a residence. The purpose is to target the particular harms that come from residences or buildings that are specifically for the purposes of either manufacturing or distributing drugs. And here, this was Mr. Rivera's home. There's lots of evidence. I encourage this court to look at the photographs in the excerpts of record. It is furnished. There are decorations on the walls. There's a television. There's a foosball table. There's an arcade game. There's beds. There's a full dining room. This was Mr. Rivera and two other people's primary residence. And the mere fact of the presence of drugs doesn't make it a stash house. So the the guideline specifically is concerned with manufacturing and distributing. There is zero evidence.
But in this case, there's a lot of evidence of what this man and his girlfriend were doing. Doesn't that convert it into a stash house?
I'm sorry, what they were doing?
Putting things down the toilet and all that sort of thing.
Well, right. So the presence of drugs in the house is sort of one piece of evidence.
Right.
The jury instruction, the notes in the the notes in the guideline instruct this court and the sentencing court to look at the uses, the lawful uses of the house. In this case, living there, sleeping there every night, having meals there presumably, and compare those to the unlawful uses of the presence, which in this case involves storing some amount of methamphetamine in sort of a side table or a safe near the bed. There's no evidence of manufacture. There's no laboratory equipment. There's very little evidence of any sort of regular.
Forgive me, I may be wrong, but I thought there was a scale that had residue on it. Am I mistaken?
There was a scale. By manufacture, I mean producing the actual methamphetamine.
Understood.
So
okay.
the guideline mentions manufacturing and distributing methamphetamine. There's little to no evidence that.
So is your position this guideline can only apply if they were actually manufacturing the meth?
Or distributing.
Or distributing.
Right.
Okay. So I mean, the scale, the problem is some of your arguments were aimed at manufacturing, but right. The scale, as Judge Smith pointed to, why wouldn't that support distributing?
So the question is whether meth distribution was a primary purpose of the residence. The mere presence of a scale and some amount of methamphetamine isn't enough to support the idea that this was essentially a stash house. That is a place for which.
Well, I wonder if you're overstating. I mean, I guess. It's hard to know. We haven't really addressed this in a published case.
That's right.
The closest case I could find was the Johnson case from the Sixth Circuit. And do you think? I mean, if Johnson were the law in the Ninth Circuit, how would you distinguish it?
So I think Johnson is distinguishable for several reasons. First, dealing from the home was proven in Johnson. That is, there was evidence of actual drug transactions occurring in the home. We have little evidence of that here. There's some speculation based on one of the text messages maybe 15 months ago, but that text message also references going to a Burger King. In Johnson, there was a separate storage room.
In your view, does the enhancement require the drugs to be exchanged at the home, or would it be enough to store the drugs there? Weigh them out, conduct the business there, and then drive to the Burger King and exchange it.
Well, so the enhancement is concerned with distribution. So the question is, what does distribution mean? If the primary purpose of the residence is distribution, I think that at least interpretively, that seems to imply that the distribution is happening at the residence. And the enhancement is based on a statute. Is based on a statute passed by Congress that was particularly oriented towards the unique dangers of, semi-vacant buildings or vacant buildings that people go to purchase drugs, and how those lead to crime, those lead to lots of people hanging out and using drugs in that place or nearby. There's violence. The concern was abandoned or semi-abandoned buildings that exist for the purposes of either making drugs or selling them, and are known as a place where people go to buy drugs, and that's just not present here. The purpose of the enhancement was not to add additional sentencing time to people who live in a residence and are also drug dealers. The problem the enhancement is oriented to is stash houses.
Well, but Johnson didn't seem to take that same interpretation. I mean, as I read Johnson, it said that, yes, it's true, incidental storage would not be enough, but it equated incidental storage with casual use, meaning, if you're just bringing in your own personal use, that's not going to be enough to show distribution. But the question is, do we have more than that here?
Well, so other distinctions between this case and Johnson. In Johnson, it was marijuana, and there was a separate room in the residence just for the purposes of storing marijuana. Here we have, these Ziploc bags that contained methamphetamine in the bedroom. that is one at sort of like a chest next to the bed. And so that's that's another distinction. In Johnson, there's this separate sort of facility or room within the apartment, the purpose of which is the storage of significant quantities of marijuana. There's also significantly more cash found in Johnson's. $15,000 are present. So I think it could be distinguished on the facts there. And sort of the key, analysis is looking at the factors that make it a stash house and looking at the factors that make it a residence. And here, there's quite a bit on this side of the scale of it being a residence. That is, they live there, they get their like bills sent there. There's all the sort of photographs of a lived-in residence that are present in the excerpts of record. I'd like to move on to the Second Amendment issue, if I may.
Yeah,
I can say we can dispose of that rather quickly with Duarte and Bongstray, can we not?
So Duarte and Vangste concern the possession of firearms. The distinction we're making is that here, Mr. Rivera is being prosecuted for the possession of ammunition without any sort of charge involving firearms. And,
all right, so you're saying this is not a 922G1 issue?
Right. So yeah, so this is distinguishable from Vangste and Duarte because there's no, Bruin instructs us to, when looking at any particular firearm regulation, to ask if there is a tradition of regulating that particular kind of firearm. And as we argue in our brief, such a tradition is absent in the United States. The Second Amendment clearly covers ammunition, and the only laws from sort of the founding period that the government is able to point to that regulates ammunition alone, or that would apply to ammunition alone, are sort of discriminatory and invidious in a way that this court's recent decision in the open carry case suggests should be disregarded.
So whether you're right or wrong on that, I think we've got a bigger problem. As I understand it, this wasn't raised in any pretrial order.
That's true. So we argue that this is a jurisdictional issue, that is, that the facial unconstitutionality of this kind of prosecution can be raised on appeal for the first time because it goes to the court's jurisdiction over the case, and we have cases showing that. And so that's the basis on which we argue that this court can reach the Second Amendment issue. I
see. So not a facial application, but you're just saying, hey, we got to invalidate the law.
So invalidating the prosecution of ammunition alone. Yes, that's right, Your Honor. Okay, so and then I'd like to move, if I may, to the expert witness issue. So in this case, Agent Nearing, who was the main trial witness and the source of the overwhelming majority of the government's evidence, was permitted to testify essentially indistinguishably as both an expert witness and a fact witness describing what actually happened.
Well, okay, so I mean, you said indistinguishably. I think that I don't think we should gloss over it because that seems to be where the case seems to rest on. Because I have a little bit different take, perhaps, on that, and I'd like you to address it. The district court did say, like, look, you're gonna testify as a fact witness first, and then he brought him back later as an expert witness. You don't disagree with that?
That's correct, Your Honor. The district court said that, and the district court instructed the jury that was happening. Right. The problem is that did not happen, right? So
during the fact testimony, there were certain positions. Now those were okay. And those were all objected to, correct?
So the discussion of. So Agent Nearing's use of his expert testimony to testify about how much methamphetamine is normally in a Ziploc bag, that was objected to. And the defense counsel also objected sort of at the outset of the trial that the expert testimony needed to be bifurcated from the fact testimony and sought, the judge,
right.
for the judge to enforce that.
But so maybe you can walk through, because I identified basically three examples that your argument seems to, three examples of what you say are expert testimony that was shoehorned into the witness testimony category. He started testifying about trash appeared to have been full of, there appeared to be enough, what was this issue? The trash appeared to have been full of trash before, right?
Yeah, right. So basically the three harms we allege that caused this to affect the verdict are first, that Agent Nearing was able to testify based on his expertise about how much methamphetamine is normally in a Ziploc bag, which was the key issue in this trial, because the defense lawyer's closing argument was this was a personal use amount.
And you objected to that.
Yes, that was
But
objected
then
to.
didn't you agree to a dual role instruction?
So the defense counsel objected. The judge then gave a dual role instruction. The defense counsel did not withdraw the objection at that point. The defense counsel agreed to the instruction being given, but the instruction did not cure the error. The instruction merely said Agent Nearing is testifying now as a fact witness. If anything, that compounds the error because the jury is being told these are facts you are hearing. The instruction did not tell the jury to sort of
Dismiss that.
right, exactly. Not to treat
testimony.
opinion evidence as fact evidence, or to not give the agent's testimony more weight based on their expertise. In addition,
Now that with the second one, there was an instruction given to disregard the testimony about the toilet bowl residue dissolving.
that's right.
So how does that? I mean, are you still relying on that?
Sorry, the residue.
The residue in the toilet bowl was.
So that was
dissolving.
another point at which an objection was made. That's
Right, exactly. And then didn't the judge actually tell the jury to disregard that testimony?
That's right.
So
Well, so we're not relying on
Okay.
that as error. So the other, so beyond that, the sort of general, the fact that Agent Nearing was certified as an expert in all of his dozens, hundreds and hundreds of different cases and different, methods of investigation were testified about before his initial fact testimony, that unfairly bolstered his fact testimony, which is another source of error. And then third, basically Agent Nearing testified about confidential informants and what confidential informants normally do, and the fact that he'd worked with confidential informants 100 times or so, and the just sort of went into some detail during the sort of expert qualifications phase of the fact testimony about how he works with confidential informants, including saying that after he speaks with a confidential informant, he will go and have someone search the trash of the potential investigation target. Shortly after that, Agent Nearing testified that in this case, he sent someone to go find the trash of Mr. Rivera and go through it to find evidence. This, strongly suggests to the jury that there is a confidential informant in this case. There's no other potential relevance to discussing how confidential informants normally work or how often they're used. And so this potentially, this is another source of harm, potentially allows hearsay to come in. That is because no informant testified. The concern, which is also discussed in the cases we cite, is that the jury might rely on that and that sort of implication to conclude that there's a confidential informant who fingered Mr. Rivera.
Okay. Do you want to reserve
Yes.
for a rebuttal? Yeah.
Yes, please.
Thank you.
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court, David Spencer for the United States. I'd like to begin with the drug quantity issue and just correct a couple factual assertions that were made in both the reply brief and then again this morning. The first was that my colleague on the other side argued that the jury could have found that the money seized from the house, the $5,972, was facilitating property, not proceeds. The problem with that argument is that the jury returned a special verdict, and the special verdict form specifically found that the seized currency was proceeds. The jury found that the $5,972 is property constituting or derived from proceeds obtained directly or indirectly as a result of the offense charged in count one of the indictment.
So the argument seems to be that directly or indirectly is what makes that problematic to impute. Can you address that?
Yes, Your Honor. Either way, whether it's direct or indirect, the cash is still methamphetamine proceeds. Factually, it makes a lot more sense that the cash is going to be direct proceeds from a methamphetamine transaction. I don't know how cash becomes indirect proceeds unless you're going and changing out bills and getting 5s for your 20s at the convenience store or something. But regardless, it's methamphetamine proceeds, and it's $5,972. The district court could take that finding, which satisfies Gonzalez-Sanchez, as well as all the other evidence we can get to, and he can take the cash and convert it to its drug equivalent, as this court has approved as a methodology in Gonzalez-Sanchez. That leads to several pounds of methamphetamine. The court then very carefully and scrupulously followed this court's case law that where where you're approximating, you have to give every break essentially to the defendant, be as conservative as possible. The court said, I'm probably being excessively conservative, but I'm going to find that there's at least 500 grams, between 500 grams and 1.5 kilograms, which is more than supported by the seized cash that the jury found was proceeds. It's also more than supported by the approximately $5,000 in separate cash that was photographed on the phone a couple weeks before, where a court again made a specific finding that that was proceeds because he referred to how it was packaged and bundled and said that in his mind that was a more than reasonable basis to find that that money as well was drug proceeds. One other factual issue I want to mention is counsel's argued that the district court didn't consider the jury's verdict at all. That's not correct. At ER 32, as we were discussing this issue at sentencing, the district court asked me to go through the facts relating to the cash, and in doing that, I separated the two categories, explained that the cash at the house was not bundled, but the cash in the photograph was, and then I said, but the cash that was seized from the house, the jury found that that was proceeds, and the district court said, well, there is that. And so that was part of the district court's basis for his finding when he finds the drug quantity.
Does it matter? I mean, would it be error if he didn't rely on that?
I don't think it would be error if he didn't. No, the short answer is no, Your Honor. I
Because
think
the evidence would still be in there. But I mean, does it matter that I don't know? Maybe it does that the district court specifically found it. It just would seem odd that we would remand it if we found evidence in there to say, hey, make sure you point to it.
I agree, Your Honor. I think on an abuse of discretion standard, this court affirms unless the district court's finding was illogical, implausible, or without support in inferences from the facts in the record. The appellant has not met that standard. But here we actually do have this specific finding, which was something that the court looked to in Gonzalez-Sanchez. And we actually have two findings. We have the specific finding by the jury that was referenced at sentencing as to the cash from the house, and then we have the court's finding as to the other cash pictured on the cell phone photo.
Can you address the premises enhancement? Because we don't really have case law in the Ninth Circuit on this. Is it a problem? I mean, does this come up a lot, or the district court's grappling with this?
It does come up from time to time. It's certainly not true that it's applied in every case in which a defendant has drugs at his home. This case is very different because as the probation officer wrote in the PSR at paragraph 33, the trial evidence showed that the house was essentially the base of operations for this drug trafficking operation for a period of 15 months or so. There was ample evidence to sustain that. It's in the form of drugs at the house, but also as Judge Smith mentioned, you have the scale that's found there. The scale has methamphetamine residue on it, showing it's been used in the past to weigh methamphetamine. It's an 800-gram scale, which there was expert testimony that that's significant because smaller users or people dealing in smaller than pound quantities often have smaller scales that weigh lesser amounts, and so that's consistent with a pound-level dealer. You have packaging materials and a good deal of packaging materials in a separate room, and again, the size of the bags, there was expert testimony that that's consistent with pound-level dealers. These aren't the little sandwich bags that might be tied off on the corner to package small amounts. You have the text messages, which showed drug transactions happening in the period leading up to the search. There's some where he invites people to come to his home, suggesting there's drug dealing at the home. There's others where he says, I'll come out to you, where it's implies he's taking it from the home.
Does it matter that, do you think that this enhancement requires them to exchange the drugs at the home?
I don't think it does, Your Honor, for a couple of reasons. The commentary says that storage for the purpose of distribution satisfies or can satisfy the maintaining of premises. The text of the guideline, too, I mean, for the purpose of distribution can fairly encompass storage to then distribute the drugs, not just the distribution happening right at the home. So I think the commentary is really dispositive, and the plain language.
Well, the commentary is not passed by Congress, right?
That's true, Your Honor.
Okay. So is that binding on us? I mean, I think your point would be looking at the text, it supports this application here.
That's correct, Your Honor. I think the text is enough, but I think the commentary is a fair gloss on the text that this court could reach just as easily as the Sentencing Commission.
What about the Second Amendment? Oh, well, actually, before Johnson, do you have a problem with the analysis in the Sixth Circuit case, or do you think you got it right?
I think that court did get it right, and that's actually the opinion on which the district judge relied when he applied this enhancement. He rejected the argument, as other courts have, that it's dispositive that this is the defendant's home. It's not. As Johnson found, if it's smaller amounts, if it's personal use amounts, somebody has their drugs at home, sure, that's not going to be maintaining a premises for drug distribution. But when you have months of activity and it's the base of operations for this drug trafficking operation, that in Johnson and in this case rises to the level of maintaining a premises. I think it's also important, my colleague argues that the purpose of the residence has to be drug trafficking. That's not what the guideline says or what the commentary says. It just needs to be a purpose. Sure, it was a residence. He was living there, but it was also central to and necessary to his extensive and long-running drug trafficking operation. And for all those reasons, the district court did not abuse its discretion in applying the enhancement following Johnson.
What about the Second Amendment? I mean, is that not preserved, or do you think we need to address it on the merits?
I don't, Your Honor. I think it's actually more than not preserved. I think it's waived under Rule 12 in this court's decision in Brewster. There was no argument that there's good cause here for not raising it below in a Rule 12 motion. My counsel on the other side says, well, it's jurisdictional because you can adjudicate it on the face of the indictment. That's not correct for a couple reasons, but most importantly, it's not uncommon that you would have a case where someone is charged under 18 U.S.C. 922 G1 with being a felon in possession of ammunition without an allegation that there's a firearm, when factually there is a firearm involved. The fact pattern in which that comes up most commonly is in terms of ghost guns, or guns that are privately manufactured, unserialized firearms.
Because you don't want to get into the debate about whether that's a gun or not.
Well, it's a little different reason, Your Honor. It can be very difficult to show the interstate nexus element. If it's privately manufactured, unserialized, you can't prove that it was manufactured in another state or in another country and therefore must have moved in commerce to California. Those facts are often unknowable, and so therefore it can often be very difficult to prove that the firearm traveled in interstate commerce. But the ammunition can be charged, and there's many examples of indictments that charge just the ammunition.
We don't have ghost ammunition yet.
I'm sorry?
We don't have ghost ammunition yet.
Not usually, at least. Usually the ammunition is manufactured in another state. And even in this case, Your Honors, the ammunition was charged because that's what was found during the residence. But factually, there was evidence that there was a firearm. There were statements from the confidential source that the confidential source had seen Mr. Rivera with a pistol at his residence where he was distributing drugs. We didn't put that evidence on at trial because it wasn't necessary, but had there been a Rule 12 challenge to the indictment saying that there has to be a firearm under the Second Amendment, and had the district court said that, we might have presented different evidence at trial in order to satisfy that. So even in this case, there's a good reason it's waived, because we didn't have an opportunity to litigate the case that way. Even if it's not waived, it's certainly plain error review, and it can't be plain under, as one of Your Honors mentioned, this court's decisions in Duarte and Vangshe.
Do you want to address the precipient and the expert testimony from Nearing?
Yes, Your Honor. The court throughout the trial very carefully followed this court's guidance about how to handle dual role testimony from the Holguin case, from other cases. At the outset of trial, government counsel, I told the court that we were planning to present Agent Nearing as both a fact and an expert witness, and in our pretrial briefing, advised the court of Holguin and asked the court to follow those safeguards, which the court did. Specifically, the parties had an agreed upon jury instruction. That was this court's model instruction, and we agreed that would be read both during trial at the point of testimony, and then in the final closing jury instructions. That's what the court did. We also importantly bifurcated or separated the testimony into a fact phase and an expert phase. And it wasn't even just a break in the middle of the same testimony where we turned to the expert phase. We actually separated it by several witnesses who intervened and on different days of trial. So the court followed all the safeguards that are necessary under Holguin. Counsel now raises, I think, 3 instances on appeal where he says, or where Rivera says that the expert testimony or the fact testimony bled into expert testimony a little bit. It didn't. Those were proper lay testimony in each instance, and I can go through those. The first 2 issues had to do with just the background and qualifications of Agent Nearing. We covered those at the outset of the fact testimony because they were relevant both to the fact testimony and the expert testimony, and we didn't want to have cumulative testimony about qualifications. That's the testimony just generally about his background and then also about confidential informants. The confidential informant testimony was relevant foundation to both the expert testimony later, but also to the fact testimony, because as this court has recognized, lay opinion can include, and this is the Perez case, for example, indicia of drug trafficking. So Agent Nearing needed to explain to the jury that he's an experienced drug agent, that he is familiar with the types of evidence he's going to see when he goes into a home, that he's familiar with it for a variety of reasons. He's done search warrants, but he's also talked to people in the drug trade, confidential informants. And so if you ask, for example, a question in the fact stage, did you find any items of evidentiary value in a particular room in the home, the jury needs to have that foundational evidence that this is an experienced drug agent, and so he has a basis to answer that question. It did not wrongly imply that there was specific information from a confidential source that could be used against Rivera. It was just foundational testimony. And moreover, the court dutifully instructed the jury not to consider any evidence outside the record, emphasized the importance of not looking at any other sources because the jury had to make its determination based entirely on the evidence presented in the courtroom, and that rules out any of the speculation that they're worried about. Frankly, in any case in which you have government agents testifying that they're conducting surveillance or executing a search warrant, there could always be speculation that maybe the government had other evidence that's not being prevented, but the court rightly instructs the jury not to consider that and just to consider the evidence presented in court. And so the specific testimony objected to didn't even bleed into expert testimony during the fact phase. The third example actually is one that occurred on cross-examination. Defense counsel made a factual assertion about the bags being empty, and Agent Nearing reasonably responded, well, they weren't exactly empty. There were shards of meth in there, and then said something about his experience, but it was invited by defense counsel's question. So there's certainly not plain error here because the safeguards were followed. That's what this court's court's decision in Freeman teaches. If the safeguards are followed, there's no basis for finding plain error, and there was no error at all. This is, even if it were preserved, it's an abuse of discretion standard because the court has substantial deference in making these fact-bound judgments about whether testimony is proper lay opinion or not. If the court has any further questions, I'd welcome them. If not, I would ask the court to affirm.
Thank you very much.
Thank you, Your Honor.
We'll give you time for rebuttal.
Thank you, Your Honor. So I'd like to start with the jury instruction. So at 5 ER 862 is the instruction the jury was given concerning forfeiture, and it does have the language about committing or facilitating the commission of a drug violation. That language is not in the verdict form, as my colleague noted, but juries, as this court and the Supreme Court's case law have made clear, are presumed to follow jury instructions. And in a Ninth Circuit case, United States versus Espino, 892 F. 3rd 1048, there was a constitutional problem with the verdict form, and the court relied on the jury instructions to sort of override what the what the verdict form said. In this case, the jury was told you can find this is forfeitable based on the proceeds being used for sort of future commission of drug violations. And so that, in addition to the directly or indirectly language which is in the verdict form, is a basis to distinguish the jury's finding from the finding that needs to happen here, which is that it needs to be the direct proceeds of methamphetamine transactions. If it's the indirect proceeds, if it's perhaps some other drug or some like the third item that's the meth is being traded for and then being sold, or some other way in which the money is indirect proceeds, that's not sufficient to support the enhancement. In addition, so the judge did not base the amount approximation on the jury's verdict. The judge just acknowledged on the record, as the prosecutor indicated, well, there is that. But the only basis the sentencing judge gave for the drug approximation was the cash. That is, the money found in the apartment, and under Gonzalez-Sanchez, that is not sufficient. So in addition, moving on to the premises enhancement. So the language of the enhancement says the purpose, not a purpose, the purpose. So the purpose of the residence needs to be manufacturing or distribution of drugs. The storage of large amounts of drugs may be relevant to it being for distribution, but we would contend that distribution means distribution at the premises. And this is sort of underscored by the fact that this enhancement is based on a law passed by Congress and borrows language from a law passed by Congress, the purpose of which is to add additional penalties for people who maintain premises at which a lot of drug transactions occur or at which drugs are manufactured. We would point this court to the Seventh Circuit's decision in Kraft, which we discuss in our briefs, in which there was evidence of multiple drug exchanges occurring at the residence. There was evidence of the presence of drugs at the residence, but that was found to be insufficient for it to... Yes. Oh, I'm sorry. Oh, well, that was found insufficient for it to be a purpose, or the purpose, I mean, of the residence. That is, it has to be not just, a purpose, it has to be the sort of the purpose. Someone can live at a residence that satisfies this enhancement, but here, the guidelines instruct us to look at all the lawful purposes to which it was put, which include sort of living there, sleeping there, eating there, etc. Moving on to the Second Amendment issue. So it is clear from the face of the indictment that this court can decide our argument because our argument is premised on the idea that the government can only prosecute ammunition if it is also prosecuting guns. So in a situation where, as in ghost guns by hypothesis, where the government lacks jurisdiction to prosecute the possession of a gun, it cannot, prosecute possession of ammunition because there's no tradition of regulating ammunition alone. That could potentially be prosecuted in state court or some jurisdiction.
Counsel, I'm going to. You've gone over.
Oh, yes.
I've given you some leeway, but I think we have your arguments on this.
Well, thank you, Your
I
Honor.
wouldn't worry. Thank you. Thank you to both counsel for your arguments in the case, and the case is now submitted. And that concludes our arguments for the day.
All rise.